Whoops, forgot to add myself to the screen here. Looks like I should be live. Hopefully I'm up on the screen now and hopefully the audio is working. Thanks for joining me. It's hard to believe, the 50th episode, if you want to call it an episode, of Freedom is Scary. And, the reason I first came up with, well, I didn't come up with it actually. I didn't come up with Freedom is Scary. And it's something that I used to hear fairly often, usually on the internet, when somebody is having to do with, like somebody not liking AR-15s or not liking bump stocks or not liking living in a neighborhood with no homeowners association. To be free, to be a free person is going to scare some people. It's going to scare a lot of the Karens. And really, since I started this thing, it was timed perfectly with what happened all last year. So it was meant to be. Freedom is scary. And it's really about Karens. 2020 was the year of the Karen. It really was. And our life is all about the Karen now. But the entire answer to all of the Karens is really one phrase, and that's, Karen, freedom is scary. And we want to live in a free country and we want to be free people. So there are going to be times when you're going to have to be scared of certain things. It's just the way it's going to be. Dwight D. Eisenhower said, if you want total security, go to prison. There you're fed, you're clothed, you're given medical care, and so on. The only thing lacking in prison is freedom. So all the Karens out there that are, they've been watching CNN or they've been watching MSNBC or they've been watching Fox News and they're really scared. Well, Karen, you can go to prison. Just go to prison. Okay. And you can be safe there. In fact, I talked to one of my clients who was incarcerated here today, and he is dying not to get out of prison, but he wants to get out of quarantine, because anytime you get moved in a prison right now, at least in West Virginia, they're quarantining you, keeping you by yourself for 14 days, regardless of your test, regardless of changes in the science. That's just what's happening. So there's a very safe bubble that they can put you in prisons. And I'm really aware of very few deaths that they've had of COVID in prisons, especially in West Virginia. So that is going to be a very safe place for you. And if our only goal as people is to survive, then we can create these pods, and they can be high-rise pods, like some of the jails that I used to visit with the Department of Justice in some of these Rust Belt cities. They were jails that were skyscrapers. And it was like something out of a Batman movie. And they were keeping people just, instead, they don't have anywhere to go horizontally, so they're just building up. And over time, it's a really nasty place. And those probably aren't the safest COVID bubble environments, but they can probably be retrofitted. But our goal is not just survivability, it's to thrive. As human beings, we want to be able to thrive. And especially as Americans, the American dream has not been just to survive to the oldest age, but we want to be able to thrive. We want to be able to pursue our dreams. And that's not even really what this video here about is today. But I have to start making videos at some of the time of the day. If I didn't have a day job, I would, because by the time I get to the end of the day, my brain starts to short circuit. But what this video is about today here, episode number 50, Freedom is Scary, has to do with one of my own personal cases that people have been following, I think, from around the world. I've heard from people on the other side of the planet who will ask me about updates regarding this case. It's a West Virginia case, but people have been, really interested in it. And it is a bizarre case. And the funny thing is, and the reason I was sort of talking about some of the COVID stuff and the COVID fascism is that the search that took place in this case that I'm about to talk about happened on March 4th of 2020. And that's really at the very beginning. I don't think West Virginia had even been declared as a so-called state of emergency at that point. So that was very early right before we got locked down by our worthless governor, whom we know in hindsight, despite him trying to scare everybody and actually scaring everybody, actually did more harm than good by locking down the so-called free people of West Virginia, and actually spread the disease more by locking people down. But again, that's a different video. So this is about a search that happened on March 4th of 2020. And part of it was caught on video. And that's important to the story because we wouldn't be where we are here today if not for the video footage. So video footage it's been important. You know, it's been what since the 90s, since the Rodney King case. There's been this thing where if you catch the government on video and the people see it, even if the court system covers it up or allows some unjust result, if the people see it and the people are pissed, the people are gonna, the people will do something about it. And I'm not talking about rioting, but you can look at a lot of the case law since the Rodney King case, and they will bring up the Rodney King case over and over and over again. So video footage has become more and more important. And that's part of what happened in this case. It was caught on video, and it was the video footage being released to the public that spurred some sort of action here. And that also brought it to my attention because I'm actually the person who uploaded it to YouTube, but it was brought to me by my client first. And I may not have believed my client had he not captured at least some of it on video. And also important to this case is the fact that it's not a complete video. So the video footage was cut off during the incident. And that's part of what's going on here because you have a First Amendment right to record your government officials doing things, not just in public, but on your own private property, of course. And my client in that case was deprived of the ability to hold his government officials accountable because he was forced to stop recording what was happening. And that is, it's sort of like Watergate. Really, the cover-up, in my opinion, should be worse than the original crime. So hopefully we have enough people on to where we can start to get into the update of what's actually going on. And people, come on, I can see if you want me to continue, spending time that I really don't have to go through some of this stuff, which I enjoy doing, you got to help me send it out there on the interwebs. So we've got at least, almost a couple hundred people watching already and only one like. Come on. That, like I heard somebody call it the other day. Isn't that communism right there? You're listening to my substance, my content here. You're not having to pay anything. It's completely free. And you don't even, and you're just going to be a freeloader and not even hit like. I'm just joking, obviously, but please share and hit like, and especially if, I don't know how the Facebook works, but the YouTube algorithms, apparently that helps. So please do that and help get this message out there, because that's what this case is about, is putting something on YouTube and then YouTube taking it and holding government officials accountable just through shining light on it, just through exposure. All right. So before I get into that, just a couple of other updates. Let's see. I had a visitor today here at the office, and it was just a vicious dog, a vicious mongrel. I'll show you what he looked like. I barely survived with my life. There he is. So he is, he was mean guy. Also, I will be speaking, and I'm honored to do this, with a group of well, I don't know if you would even call them a group, but a bunch of constitutionally minded people at an event that's coming up in April, and it's actually a party convention. So the independent party in West Virginia gets to be its own party because they got enough of the vote in the 2020 election, at least in West Virginia, that they get to have their own party status with party platform and all that. So they're having their own actual convention in Flatwoods, West Virginia on April 10th, which is a Saturday. And I'm honored that they asked me to speak at that. And I'm going to be in a panel, I believe, with attorney Jenna Ellis and then also with Michael Donnelly. I'm looking forward to that. And here's my promo picture that they put on their website that has the bio and everything. But you got to buy tickets to this. I'm not sure exactly how much they are, but it looks like it's going to be, a lot of fun. And I'm looking forward to that. And it's being put up by, or it's being set up by the current chairman of that party. And I think that's a temporary position for him, but his name's Marshall Wilson. And if you've watched a lot of my videos, you know that he's a friend of mine and has been a client of mine. And he is a no nonsense constitutionalist. And so I'm looking forward to what he's put together there that day. So again, April 10th, Flatwoods, West Virginia. That is proper number 12, Conor McGregor's Irish whiskey. And thankfully he's still sponsoring the program here, and I approve. A couple other things. I saw this Jeep in Florida, and talk about absolute injustice. I mean, this is one of the worst things I've seen since COVID started. Secondly, I had a great trip into Ohio. And unlike Florida, where I was a couple of weeks ago, where everything was open, there was no mask mandate and all that, Ohio is still very much like us here in West Virginia, where our governor still has all these mandates out there. And we're still living in 2020, basically. And it's hard to believe, there's 1.8 million people in West Virginia. And in Florida, they have like 28 million people, third largest state, and no mask mandate. None of this fascism with these restrictions, or as the media would call it, precautions. I mean, you always got to watch the news media. It's always propaganda. But it's crazy to be down there for a week and you're in a free country once again. And you come up here or you go to Ohio and it's just, people wearing masks on their face that are just nasty and dirty, or they bring them below their nose, that they're not doing it because they want to or they think they need to. They're just doing it to comply. But again, that's a different video. I was able to score this while I was in Ohio. If you know what that is a completely welded, I think it's Texas Strength Systems power rack that followed me home from Ohio. And it doesn't really have anything to do with this video other than I was able to already set it up here at the office so that if I do have any extra time, I can start lifting again. But back to what's going on here. So this is the family court judge search case. I've done a lot of videos on it so far. This has to do with my client, Matt Gibson. There was a search March 4th of 2020 of his house by a family court judge, along with several deputies from the Raleigh County Sheriff's Office, and along with his ex-wife and her lawyer. Now, you can watch the video itself is on the YouTube channel, and it's been played several times. And I've detailed it also on the website, thecivilrightslawyer.com. But to make a long story short, there was a judicial disciplinary investigation that was opened in part because of the video being put on YouTube, and also because my client had filed a disciplinary complaint. So they went through the process of that, and they filed a formal statement of charges against the family court judge. And this is based out of Raleigh County, West Virginia, the 13th Family Court District. And it was, again, a formal statement of charges. And the way that works is it's something that happens within the West Virginia Supreme Court. And there was ultimately a settlement agreement between the family court judge, the respondent in that case, and the people who are essentially the prosecutors in that. They're called Judicial Disciplinary Counsel, I believe, or the Judicial Investigation Commission. So they found that there was wrongdoing. They filed charges. The judge hired an attorney, and they came to a settlement agreement. And I've gone over this before. So there was a settlement agreement where the judge had admitted that what she had done is wrong. She admitted all the factual allegations, and she admitted that the rules of judicial conduct, and it named all of them, were violated. And they agreed on a sanction or a punishment. And that was a maximum fine of $5,000 and a censure. Now, what a censure is confusing, but there's a thing called a written reprimand. Now, a written reprimand is not as bad as a censure, and a censure is not as bad as a suspension. But the worst they can do is a suspension. So the agreement is all right, we'll give you a censure, which is worse than a written reprimand, but it's not a suspension. And that was based on the fact that this was a long-time judge. There was no prior disciplinary history, and she was agreeable to it and had apologized and all that. So there was an agreement. There was no issue. And so this has to ultimately go to the Supreme Court, but instead it goes to what's called the Judicial Hearing Board first, and they make a recommendation, and then it goes to the Supreme Court. So things got sideways at the Judicial Hearing Board hearing. There was a sitting family court judge on the Judicial Hearing Board, which I had appeared at remotely, and his name is Judge Stotler, and he objected to basically the process and had made the argument or brought up the question that he doesn't really think that it is illegal for a judge to search a litigant's house or for a family court judge to search a litigant's house. And really, nobody was claiming that, not even the counsel for the judge. They already had a settlement agreement that was signed, but now we have a family court judge that feels like he and his colleagues are going to lose power if they set a precedent here of, it would be a shame not allowing family court judges to search the homes of litigants appearing before them. So the Judicial Hearing Board comes up with a briefing order where they want these issues to be briefed. And they said, well, why isn't it legal for a family court judge to search somebody's house? And it suggested several state statutes that pertain to the judiciary that might stand as some sort of authority for them to do that, or suggested that it might be possible to do it like a jury view, like in some criminal cases, some murder cases, or right-of-way disputes. There will be a jury view where the judge and the jury come out and view the murder scene or view the actual roadway and dispute. And so if they can do that, then why can't I, as a family court judge, do that? So there was no dispute, there was no issue, but there was at least one family court judge that didn't want to lose the ability to do this. And I hadn't heard of this happening anywhere except in this particular judicial district. So the issue is briefed, and the prosecutorial folks, the Judicial Disciplinary Council, really came out with a great brief. It was like 50 or 60 pages long. And it laid out in detail for them why it was not legal, really why it was not constitutional for a family court judge, or really any judge, to search the home of a litigant who's appearing before them. Now, to most of us, that seems like common sense. Imagine, a judge at a murder trial could just say, to the defendant, well, you said that you didn't do this, but, what's your address? Let's go to your home, and I'm going to go take a look for myself, and I'm going to go see if you're telling the truth. Imagine that happening in a felony murder case or any criminal felony case. It's absurd. It's outrageous. It rises to the level of pretty much anybody's got enough common sense to know that would be inappropriate. But for too long, family court judges, not just in West Virginia, but around the country, have sort of slipped under the radar. And, there didn't seem to be a consensus. Do you have any constitutional rights when you're in family court? Some people were saying no. And that's apparently what they were arguing is, you know what? This is family court. This is not real court. You don't have any constitutional rights. We don't need a warrant to go into your house. And so that's sort of the issue that was brought forth. And so the ultimate decision that the Judicial Hearing Board came out with that was recommended to the Supreme Court actually changed the settlement agreement. There was no dispute, but now they've lowered the agreed upon punishment from a censure, really whatever that is. I mean, it's just worse, from a censure down to only a written reprimand. And instead of the really paltry $5,000 fine, it's down to $1,000 fine. So they still found that there was wrongdoing, but they wanted a lesser punishment. And so that's their recommendation to the West Virginia Supreme Court is, yeah, she violated all these rules and she was very bad, but it should be a lesser punishment than even she agreed to take. And that was really disappointing, I know, to my client as well. And I think a lot of people thought, probably including us, that even the original one wasn't really bad enough, but just, not knowing the process and being explained the process, that there are a lot, it's a disciplinary proceeding. So you look at prior behavior and relationship, other good things you've done. So it's sort of a balancing thing. But now, not only did they lessen the proposed punishment, but there are family court judges, or at least one, that's taking the position that this is legal to do, and which is just absolutely outrageous. Even to suggest that there's some mechanism under state law that says that a family court judge can go to your house against your will without a warrant and search and then seize items inside without obtaining a warrant or without meeting any of the constitutional exceptions to the warrant requirement, is outrageous. It completely ignores the federal Constitution. It completely ignores the Fourth Amendment. And it completely ignores the West Virginia Constitution. Because the West Virginia Constitution, I recommend that you read it. It's a simple document, and it establishes that the U.S. Constitution is the supreme law of the land. And that the very purpose of the state government in West Virginia, of which family courts are a creation of the legislature in West Virginia, their very purpose is to, let me read this exactly the way it's written. Their very purpose is to guard and protect the people of West Virginia from any and all encroachments on their liberty. That's a joke after last year, I know, but still. The Constitution, our state Constitution, reads, the state of West Virginia is and shall remain one of the United States of America. The Constitution of the United States of America and the laws and treaties made thereof shall be the supreme law of the land. Government of the United States is a government of enumerated powers, and all the powers not delegated to it, nor inhibited to the states, are reserved to the states, to the people thereof. So in the end, it says that the people of West Virginia are to be protected by their government from all encroachments upon the rights so reserved in our Constitution. In fact, it also says, not only that, our government officials are supposed to be our servants. All power is vested in and derived from the people. Government officials, bureaucrats, I'm reading from our Constitution here. Government officials, bureaucrats, politicians, and the likewise are the, quote, trustees and servants of the people, and, quote, and at all times amenable to them. It's West Virginia Constitution, Article 3, Section 2. But obviously, that's not the case. The government at every level has obviously taken the position that they are not our servants, that they are not amenable not only to us at all times, they are amenable to us at no time. So what is the update that we have? The update from today, this is something I've been working on for quite some time. People have been asking me what we're doing. When is something going to happen on this case? Well, everything that's happened so far has been the disciplinary procedures. And I've really had no control over that. And I've been very happy with, and my client has, with the hard work by the people that prosecute those. I mean, it's not their fault. Hopefully they still may win out in the end. But the system is it seems like it's rigged. It seems like it's rigged. I mean, just like we can't get any good rulings on any of the COVID fascism. When you have a judge caught breaking the rules, it looks like he's going to get out of it with a slap on the wrist. Well, not if we can help it. So you'll be really the first to hear it now. But what we did today is we filed a federal lawsuit against the judge and other people that were involved in the search of Mr. Gibson's house on March 4th of 2020. And I have a copy of it right here. It's so brand new, it doesn't even have a case number, but it was filed this afternoon. We paid the $402 filing fee, and that's what it costs to file a federal lawsuit in the Southern District of West Virginia. And it's now pending. So I'll show it to you. Somewhere. All right, there it is. So again, doesn't even have its case number yet. So there's my client versus Louise E. Goldston. That's the family court judge. The County Commission of Raleigh County. That is Beckley, West Virginia. That has to do with the deputies. And so here are the deputies from the Raleigh County Sheriff's Department. Jeff McPeak, and he was the bailiff. Brian White and Bobby Stump. Now, those were the deputies who responded to the scene and then became involved in the search. Now, the last defendant is not actually a government official. Kyle Lusk, he is the attorney for my client's ex-wife, and I'll explain why and how he is a defendant in a federal civil rights lawsuit when he is not a government official, which is generally the requirement to sue somebody for the violation of civil rights. So this is filed under Section 1983, and here are the violations that I've alleged here. The Fourth Amendment is all federal violations. So in a Section 1983 claim, you can't point to state law violations and maintain a Section 1983 federal civil rights claim. You can also add state law claims, but those wouldn't be under 1983. So we're talking about federally protected rights. So the Fourth Amendment, everybody knows that. Where are we? Fourth Amendment. Also, the First Amendment. Again, this has to do with making them stop recording, and I'll get to that. And then the 14th Amendment. Well, what is the 14th Amendment? Life, liberty, and property, basically. Due process, equal protection. So we've got a lot of alleged federal constitutional violations here, alleged for March 4th, 2020, very beginning of all the craziness from last year. So as you do in any civil lawsuit, you go over all the facts, and you'll see that I'll post this on the website at thecivilrightslawyer.com, but you'll see that one of the things you have to do in federal court in civil rights cases is you have to be very, very specific. So I never want to get kicked out on a motion to dismiss for lack of specificity. Whereas in state court, you'll see in all these car wreck cases, they're very, very vague because they can be, and they sort it all out after the lawsuit is filed. So in the exact opposite fashion here, we've alleged every fact pretty much that we knew to be a fact in this case. So you can go over it when you see it, but basically the gist of the matter here is that there was a thing going on in this particular county, in Raleigh County, Beckley, West Virginia, where it wasn't just this family court judge. There was one other newer family court judge that performed a couple of these searches. But I haven't found where this has been going on anywhere else in West Virginia. But in this one family court system, you had these so-called home visits happening where the judge was willing to come and search a litigant's house, like in a divorce case, to see if certain items of personal property was there and seize those items. And this was not only being done over the course of 20 years, But it much more than that, I think it was threatened. So when two parties get to their divorce hearing, there's threats going on in the negotiations between the lawyers, or even if one of the parties are pro se, which means you don't have a lawyer, that, well, I'll get the judge to go to your house and see if those items really exist or whether they're really in your house, and we'll see if you're lying. Or you can pay my client $1,000 or whatever it is for items X, Y, and Z, and we'll forego that home visit of your home by the judge. And so that's being threatened in a lot of cases. So this one particular lawyer in particular, you'll see that we've alleged that this wasn't the first time that he had really, a year earlier, when my client was going through a divorce, the original divorce, he was caught on a recording that we have now, threatening to go to my client's house to search it back then. This is when they were negotiating over these things. And he said, well, what I want to do, and he's talking to his lawyer at that time, what I want to do is put your client on the stand and have him say that certain things aren't there at his house. And this is not the marital house anymore. Certain things aren't at his house, and we'll get the judge to go there and see, and it'll be a great time. So this was threatened like a year earlier. And we've alleged that this was done in other cases and threatened in other cases. So it appears that there was this sort of ring going on with this relationship between not only this lawyer and judge, but other lawyers, and sort of an inner circle. It seems that it was sort of a quid pro quo type deal going on, where you have this judge doing these searches, these home visits of litigants' homes at the request of lawyers. And then in exchange, it seems like, at least with this particular lawyer, that there was support to keep the judge in that position. So political donations, or just general political support, social support. And as we've alleged, that helped keep this person on the bench for 26 years. And who is that unfair to? And this is where we get to the equal protection and the 14th Amendment claims, is who's getting the short end of the stick there. It's people like my client who, for instance, can't afford, or couldn't at the time afford, an attorney and have to go in there and represent themselves. They're getting disparate treatment. They're getting unfair treatment because the judge is admittedly impartial in favor of this lawyer, of the lawyers. And whether or not she's getting something in return, she's agreeing to basically join one side. And that's sort of what happened here, is she, as alleged here, as she admitted, improperly putting herself in the role of a litigant in a divorce action or in a contempt action. And that's really what was admitted here. And so it's about much more than this one particular search, but it's about sort of the whole unfairness of this scheme that was going on. And while you might suspect that you're getting the short end of the stick, you're getting shafted when you go to family court and you didn't hire the right lawyer, this is really showing how that specifically worked. So looking back at the lawsuit here, so this judge was there for 26 years, and over the past 20 years, been engaging in the visiting of homes of litigants who appear before her. And this was to determine whether certain disputed marital property was present and to supervise the transfer of the disputed property. She admitted to conducting these home visits in the capacity of a family court judge on 12 separate occasions in different cases. And it may have happened more than that. And there's a statement that came up in one of the recordings where she said something to the effect of, well, it happens all the time. We do it all the time. So September 18th, 2020, that's when the charges dropped. The West Virginia Judicial Investigation Commission filed a formal statement of charges following the commission of the so-called home visits. And this is regarding my client, Matthew Gibson. This alleged that there was probable cause to formally charge the judge with violations of the Code of Judicial Conduct, and they believed that formal discipline was appropriate. So, let's see. The judge agreed to it, and let's just go on to the law, because this would take all night. See, I left no stone unturned here. We went through all of it. For instance, this is from the settlement agreement. Where is it? All right, the judge admitted to violations of Rule 1.1, 1.2, 1.3, 2.2, 2.4a, 2.4b, and 2.5 of the West Virginia Code of Judicial Conduct. Now, imagine that you're in any court, much less a family court, but let's just say you're in a criminal court, and you admit to violating, laws 1.1, 1.2, and so on. What's going to happen to you? You're about to get screwed. But here, you'll see that there is a double standard, that rules are for thee and not for me. But we had a settlement agreement, which the judge signed. But again, the Judicial Hearing Board basically threw that out. We'll see what the Supreme Court does. And if you've watched the video of my appearance at the West Virginia Supreme Court the other day, along with the result of it, then maybe you don't have a whole lot of faith in that, because that case, although we ultimately lost, there's still no written ruling, no explanation of why we lost that case. All right. Before I get to the law itself, here's a couple of the other cases. So we got a lot of phone calls from other people who had similar experiences in this same court. And this one was particularly troubling, to use a word that the media uses all the time. It was troubling. Okay, and here's why. And names are not named here. Names are not named. So one prior litigant said that in her divorce proceeding, she had been advised by her lawyer that Judge Goldston, who was the presiding judge in her divorce, was well known for packing everybody up from a hearing and taking them through the house. Such a possibility caused her severe anxiety because she didn't want her ex-husband in her private home, which had not been the marital residence. She stated that she was a victim of abuse during the marriage, and she did not want her ex-husband in her home, which who would expect that when you're going through a divorce, you're living in a different house, you're legally separated, who would think that the judge is going to come in your house and bring your ex-husband into your house to look through your stuff? Nobody would expect that. And indeed, there's no basis. It's not written into the law anywhere in West Virginia that can happen. Even if it was, that would be unconstitutional for reasons that I'll explain. So the woman's lawyer and her ex-husband's lawyer were talking with the defendant judge outside of her presence. And that's a lot of what's happening in family courts. And I've been involved in that as well. Is a lot of times what happens is you talk with the other lawyer before the hearing, and sometimes you both go in there, and that's important. Both lawyers have to, if you can go in and talk to the judge about a case or ask questions or talk about logistics, but both lawyers have to be there. But sometimes that can leave the party or the litigant or the client thinking like it's not a fair process because they're not even seeing the judge. You have the lawyers going in there and negotiating with each other and with the judge. But that's what was happening in this case. She said that her lawyer and the other lawyer went and talked to the judge. She wasn't there, but her lawyer comes back and says, all right, here's the deal. You can either pay a certain amount of money to your ex-husband, or else the judge is going to take the lawyers and take your ex-husband and go into your home, into your private residence, to search for whatever items the ex-husband says he wants out of your house. And my understanding, he never lived in this house. This is her house. So in order to avoid this, she said that to avoid the judge and the ex-husband going into her home, she was forced to literally write a check there on the spot, even though she didn't have the money, right there in the family court before she got to leave the building. Even though she never personally even saw the judge that day, she was so scared of this happening that she just paid up and left. Didn't even want to be a witness in this case or any other case, just wanted to tell her story. And even said that her mother and her daughter were right there, witnessed the whole thing. Another person that we had talked to that we specifically pointed out in the complaint as an example of the sort of thing that was going on here in this family court circuit, this involved the other judge. Now, this judge, Eric Schuck, was a new family court judge, newly elected in the same family court judicial circuit. And he ended up getting a written reprimand for doing the same sort of home visits. And in that reprimand, he blamed Judge Goldston, saying that his colleague, did these. And so he thought it was legal. And they let him off with a written reprimand because he was new and was relying on, years of seeing what this judge had done. But we did talk to somebody who was involved, had their home searched by this judge who was following Judge Goldston's example. And basically the person said that his ex-wife's lawyer was the same lawyer that was involved here, Kyle Lusk, and advised that this lawyer requested that Judge Schuck to go to his home in order to search for personal property, and that occurred. So this other family court judge, from the same judicial circuit, came in his house and was at the request of the same lawyer that's involved in this case. And he stated that this lawyer was pushing Judge Schuck to take this action. He recalled that Lusk said, quote, "I think we just need to make a trip over to his house and have a look." To which the judge responded, "I think that's a good idea. That way we'll know who's lying." This guy recalled that many of the items seized during the home visit search were items which had never even been discussed before in the divorce action, such as pots and pans and Christmas decorations. And neither one of these people that we alleged as examples of other conduct that was going on knew my client or had anything to do with my client. These are just random people that saw it out there in the news and reached out and didn't even want to be witnesses or involved, just thought that people should know. So there were lots and lots of calls of other people who had either experienced these visits or had the experience of being threatened with these visits that just were so scared, didn't even want to be involved, even as an unnamed example. So this was a long-standing 20-year practice, at least between the lawyer involved here and the judge involved here. They called them home visits. But what they really did was violate the federal constitutional rights of litigants appearing in this particular family court circuit. And so we allege here that the defendant lawyer profited from this conspiracy because he received the benefit of being able to leverage these home visits against opposing litigants and counsel, as he had done to my client. And part of the reason, what I call this is the welcome stranger tax. And I've never seen one this bad, nor did I have any experience like this. But you go and travel into a court somewhere and they have the same, they have their own lawyers and you're an outsider. And a lot of the times you'll feel like anyways, like your client is getting unfair treatment because your client's being punished for bringing in a lawyer from the outside who's not part of the inner circle. And I call that the welcome stranger tax. But this really brought that to a new level. So my client's divorce, he actually had a lawyer. And this same lawyer that represented the ex had threatened my client's lawyer. And my client's lawyer had been a federal prosecutor. He was a top-notch family court lawyer. But what is he going to do? He comes into there from the outside and he gets threatened with this guy bringing the judge to his client's house. It's just crazy. So they made a deal and I guess got out of there, but there was a lot of that going on. So here's the law behind it. And I went through everything and there are really no similar cases or no similar enough cases to really go off of. So a lot of this is creating the wheel from scratch, basically. And there's really been no case that's similar enough to this in the civil litigation context to really be comfortable with going off of. But there's a lot of case law out there on the Fourth Amendment. And it should be very clear that you can't search somebody's house if you're the government without a warrant. Now, of course, there's not a lot of case law saying a judge can't search a person's house without a warrant, but that's because judges don't search houses. It hasn't come up because it's not supposed to come up. But we lay it all out there, and that's what I like to do because I don't want to lose for not putting enough in. I lay the law out there. I lay the facts out there, and this is what it comes down to. Fourth Amendment of the U.S. Constitution. It says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, Article 3, Section 6 of our state constitution provides pretty much exactly the same protections. So that's the basis of all search and seizure cases, at least in federal court, Fourth Amendment. Okay, so the basic law, the basic rule of Fourth Amendment law, especially in the House, search and seizure law, is the government cannot come search inside your house without a warrant. And if they do, it is unconstitutional unless they can prove otherwise. So by default, it's unconstitutional. So the Fourth Amendment requires that law enforcement and government officials seeking to execute a search inside the plaintiff's home must apply under oath to a neutral magistrate or judge for a warrant supported by probable cause prior to entering and searching a home. Basic 1967 U.S. Supreme Court case law, Katz versus United States. So it's undisputed there was no search warrant in this case. No search warrant at all. In fact, my client had said, "You're not getting in my house without a warrant." And the judge said, "Oh, yes, I will." That was caught on video. And that was absolutely outrageous. That's not something I thought I'd ever see as a judge saying, "Oh, yes, I will search your house without a warrant." I mean, that's just bizarre. So not only was it searched, but items were literally seized inside. So it literally was a search and a seizure. And the home, we all can agree, is highly protected under the Fourth Amendment. So there's no reasonableness analysis in your home. So it's not like you're at a traffic stop and the judge is going to examine whether or not the length of the stop was reasonable or the scope of the stop was reasonable or whether they gave you some sort of rectal exam that was unreasonable. I mean, there's no reasonableness balancing test. You're not looking at the totality of the circumstances. I mean, it's just a per se unconstitutional act to perform a search in somebody's house without a warrant. So then it's on them to prove that either they had a warrant or that one of the two established exceptions of the warrant requirement could apply. And the only really exceptions are voluntary consent or exigent circumstances, or that it's an emergency situation. So the big issue here that comes up, and one of the first questions is well, this is, if you're a judge, you're not a police officer. So does the Fourth Amendment even apply? Do you need to get a warrant if you're a judge? And just setting aside the ridiculousness of the thought of a judge searching, we can answer that. Yeah, the Fourth Amendment does apply to civil cases as well as criminal. So there's authority to that, and you can read it in the lawsuit. But for instance, in 1967, the U.S. Supreme Court held that administrative inspections to detect building code violations must be undertaken pursuant to a warrant if the occupant objects to the search. So what had been going on when you had the lawyers involved? So one lawyer in a divorce case, one lawyer is requesting that this home search and seizure takes place. And then you have the other lawyer on behalf of their client consenting to it, at least arguably. And so it technically, maybe the Fourth Amendment isn't implicated if everybody's agreeable. I mean, if it's your house, you can bring in Dr. Fauci if you want to, and he doesn't need a warrant. He doesn't have to meet any particular legal standard because he's in there with your permission, just like you have permission really to bring anybody in there. But here, what distinguished this situation is that my client did not have a lawyer that stupidly consented to an illegal search of his house. He had the nerve to say no when they got to his house, and to video record it, and to audio record it, and to object to it, and to demand a warrant. And so now, for the first time possibly, the judge is in a position of, well, okay, well, if the person is objecting to me going into his house, do I still go into his house? And obviously chose the path of going into the house over his objection, and even threatening to arrest him if he tried to stop her. When very easily it could have been a different situation had she say, all right, well, if you're objecting, let's not do it, or we'll leave. But that's not what happened. So it's undisputed they did not get a search warrant, and they did not obtain voluntary consent to enter, because you can hear on the recording that my client was threatened with being arrested right then and there if he didn't consent, or didn't basically just get out of the way and let his house be searched and seized. And I believe that he was threatened with arrest 7 times that day. I mean, imagine that's your divorce hearing. It ends up inside your house, and you're threatened with arrest 7 times. I mean, that is a bad day in family court in West Virginia. Now, even though it shouldn't be necessary, we go through the fact that there's no state or federal law or rule of procedure for courts that authorizes a family court judge to search a litigant's home, obviously, nor to verbally authorize law enforcement to search somebody's home. And because why? What if there was a West Virginia rule of family court procedure 37.25 that said, on the request of a party, the courts can move the hearing to a litigant's living room and look for items that are alleged to be marital property wherever they may be found in their house? I mean, what would the problem with that be? You couldn't just say, oh, well, that rule allows it. No, it violates the federal constitution, at least unless the person doesn't consent to it, because you have a government official going in, or even directing other people to go into a house to perform a search and to actually seize items. It doesn't matter that it's not a criminal proceeding or a criminal investigation, because we know from the Supreme Court that administrative actions by the government are also covered. There really are only a few exceptions, and it has to do with highly regulated industries like coal mines. There are some exceptions for coal mines. Possibly restaurants. I looked at this a lot in my restaurant case that I filed, but we're not talking about that here. This is family court. Okay, this is not even really a divorce. I mean, it's a year afterwards. It's just the ex-wife saying she didn't get everything she was supposed to get in the divorce a year earlier. So even if there was state law authorizing this to happen, it would be unconstitutional, because a state can give its citizens greater protections, greater freedoms, more liberty than the federal constitution does, but it cannot grant them lesser protections. The West Virginia legislature could never say, well, we believe that police, because freedom is scary, we believe that police in certain circumstances ought to be able to search the home of anyone that they subjectively believe could be a terrorist, without having to get a warrant first. Some sort of broad exception to the Fourth Amendment requirement, even if authorized by the West Virginia legislature, could not stand constitutional scrutiny. It would be unconstitutional under federal constitutional law, because states can grant greater liberties, not lesser. They can allow their citizens to own AR-15s. They can allow their citizens to conceal carry without a permit or with a permit. They just can't grant lesser. For instance, that's not a great example in the firearms or Second Amendment area, because there's not a whole lot of federal rights that the Supreme Court's ever found. But for instance, you couldn't say that nobody can have a pistol in their home for self-defense, because then that would violate Heller. So that would violate the Second Amendment. So a state could not violate the federal Second Amendment protections. So again, that's a different video, but that's the point here is federal law is the supreme law of the land. It is the supreme law of the land on, where it's supposed to be. So unless it's something that's reserved to the states, which the Fourth Amendment is not. The Fourth Amendment has been applied to the states. So you can't, if you're a state legislature, violate the Fourth Amendment. And so here we get to immunity issues. I've addressed this in the lawsuit, but what we had here is the defendant judge engaging in non-judicial actions. So these were not taken in a judicial capacity. She engaged in functions and behaviors which are not normally performed by a judge and which are wholly outside the expectations of litigants in family court. So at the judge's personal discretion of and personal participation in the search and seizure inside the home, that was more of it was an executive act, like the executive branch, like law enforcement, rather than an act that was judicial in nature. So as a consequence, according to Supreme Court case law, Judge Goldston does not therefore enjoy judicial immunity for her actions, which is basically absolute immunity for the March 4th, 2020 search. So then what do you have? You have qualified immunity. So we still have to get through qualified immunity. And there are 3 law enforcement officers who were inside my client's house. So they're all being sued for Fourth Amendment violations. So we have to get through qualified immunity for them as well. And so here are the allegations that do it. No objectively reasonable government official or law enforcement officer would have reason to believe that they did possess authority to conduct the warrantless search and seizure of a family court litigant's residence in order to find items of personal property sought in a contempt petition and then seize those items. Any reasonable person would have known that the plaintiff possessed a clearly established constitutional right to deny entry into his home, demand a warrant, as he did on March 4th, 2020. So that's a basic and fundamental constitutional question that is really so clear and entrenched in our law that it's beyond debate. So it's not even close. Shouldn't be close. You don't have a warrant, you don't go in unless you have voluntary consent or exigent circumstances. So you should not be entitled to qualified immunity for doing so. The bigger issue is the judicial immunity question, which there's not a whole lot of case law on judicial judge searches, as I've stated, because they're not supposed to happen. They don't happen. That's like saying, well, we don't have any case law on what happens when judges rob a 7-Eleven, because it shouldn't happen. So here's the second one, and I spent a lot of time on count 2. So that was the Fourth Amendment we talked about. So here is what I think is important here is the First Amendment. And I had a lot of people suggest this and ask, are we going to bring up the First Amendment in this case? And yes, we did. So Congress shall make no law abridging freedom of speech. First Amendment. Through the 14th Amendment, that is applicable to the states. So that's just technical legalese. But here's the point. My client engaged in protected First Amendment speech and activity when he began to video and audio record what was happening on his property. So he had his girlfriend, significant other, who was a bystander to this, who was filming the video that you've seen. And then my client was filming using his phone, or recording audio. Both individuals were ordered to turn it off, and they were threatened with arrest if they tried to continue to record or to even turn them back on to record. And this is these threats, these orders to stop filming. This is all taking place on private property, on my client's property, in his front yard and inside his house. So the First Amendment has been applied to recording audio or video footage of public officials, where people are recording them to try to document, misconduct of their public officials. And that's exactly what's happened here. Now, several federal circuits, and if you're not familiar with federal circuits, here's my handy map. So several federal circuits have found that there is specifically a constitutional right to video record the police, because usually it comes up in the context of police videos recorded in public. Now, if you saw my argument at the Fourth Circuit here a couple of weeks ago, you might see where this is going. But the Fourth Circuit, at least to my knowledge, for the time being, has not specifically said that. But other circuits have. And the U.S. Department of Justice has taken that position for many years. But just because the Fourth Circuit hasn't said that doesn't mean it doesn't exist. And still, we're talking about private property. So they could try to claim, in other words, that there is no First Amendment right to record government officials or police because we're in the Fourth Circuit and they haven't specifically said so. But I think that's a losing argument. And you know what? Maybe this case goes up to the Fourth Circuit, and this is the one where they actually look at it and they say that you do have a right to record what your government is doing for the purposes of holding them accountable, whether on private or public property. Maybe this is that case. I don't know. There have been a couple cases where they came close to it, but I can't imagine it hasn't come up enough to where they haven't ruled that yet. So that's just an aside. It should not. I don't foresee the federal courts here holding that my clients didn't have the right to videotape what was happening, right? I think it's more likely, as we might see in that other AR-15 case, that they say, well, we don't quite have to get to it because this isn't a criminal case. This is a civil lawsuit, and we can just find that it's a close enough gray area that we're going to grant qualified immunity. So we're getting down in the weeds here a little bit, but the point is, just to bring this back, is that I believe there is a clearly demonstrable First Amendment right, even in the Fourth Circuit, to videotape police officers or other government officials or judges when they're engaging in what you believe to be misconduct. But I went through some of the other case law here that we can point to from other places around the country. Let's see, where is it? But I laid the foundation for this. I explained why video recording is important. So it protects the public's right of access to information about the activities of their officials. So it's not just about freedom of the press and self-expression, but it's also about prohibiting government from engaging in all this tyranny. And there's a good bit of case law on that about and observations that you can cite about why video footage is so important to liberty and to the constitutional rights of Americans. There's just a lot out there on that. So that's really not a problem. So it's about the free flow of information concerning public officials, their servants. And of course, that's just a joke. I mean, obviously the government does not see themselves as our servants anymore, which they should be. They should be at least our employees and accountable to us, but they're not. And it's been going in that direction for a long time. And that's sort of what you see in this video, is just the government out of control, really. So video is good, basically. So our video footage in this case was cut off under the threat of being put in jail right then and there. And again, my client, if you've been following this, you'll know, is and was a federal law enforcement officer. And he knew what was happening. He knew what was going to happen if he tried to stop them from going in his house, is he's going to end up with force being used against him. He's going to be physically arrested. He's going to be put in jail. And then what's going to happen? He's got minor kids, and the custody's still ongoing even after a divorce is finalized. So he's going to lose his kids after that because, obviously they're not going to put kids in cages, right? With their father even. So he's going to lose his kids. So he had a lot to lose by enforcing, his constitutional rights in this case. And so it's understandable why he didn't, but at least he did challenge and make an attempt and preserve the evidence. And he recorded enough of what he needed to be able to show it to someone like me and to show it to people on YouTube and on the Facebook to see what actually happened, that they wouldn't believe you unless they were able to see it with their own eyes. So to record what there is for the eye to see or the ear to hear, it's kind of like Dr. Seuss, but again, that's another video, corroborates or lays aside the subjective impressions for objective facts, because any trial lawyer knows that video is great. Witness testimony, which is so-called direct evidence, is notoriously awful. And they ran this thing in law school, in this criminal law class, I think it was. May have been the criminal clinic where we represented juveniles, but they got the whole class together in one room and they played a video of this guy walking down the street. He drops off a package at the stoop of this row house, then he keeps walking. Then they cut the video off and they start asking people questions like, all right, well, let's see, what did we see? What color shirt was the guy? And then there's like 4 or 5 different colors that people remember seeing. All right, and looking at the row houses, which house was the package actually dropped at? There's like three different stories of which house, because you don't know ahead of time what you're looking for, and you're just recollecting it, and your mind is basically full of crap. I mean, it distorts your memory, it lies to you, whatever. It demonstrates the fact that eyewitness testimony is just not credible at all. So video, you don't have that problem. It lays aside subjective impression for objective facts. So to record is to see or hear more accurately. Recordings also facilitate discussion because of the ease in which they can be widely distributed in various forms of media. And that's what happened here, is people were upset at what they saw. The government took action because people were upset. It was out there. Accordingly, recording police activity in public falls squarely within the First Amendment right of access to information. So if the press can do it, so can the public. And that's what the case law says. If it's not just a so-called journalist that gets to exercise First Amendment rights, but we all have that same right that a journalist does under the First Amendment to record information and access to information. That's why we can file FOIA requests, right? It's not just a journalist. You don't have to show your New York Times passport to submit a FOIA request. You just submit your FOIA request because the First Amendment applies to all of us. So you have this right to record, photograph, film, or audio record police officers doing official police activities in public areas. I don't even think there's not a whole lot of cases on private areas because it shouldn't really come up. Because if you're on your private property, generally it wouldn't come up because you have a right to record or do whatever the hell you want, hopefully, on your private property. But I think it doesn't not apply because you're on private property. So Fields v. This is the federal case law on recording police that really is applicable at the moment. Again, no direct Fourth Circuit case, but here we have a Third Circuit case from 2017. That's Fields versus City of Philadelphia. And that's really the biggest case right now on the right to record police, is Fields versus City of Philadelphia. Again, Third Circuit. There is a Supreme Court case, ACLU versus Alvarez, which is helpful. And Seventh Circuit case, but cert was denied by the U.S. Supreme Court case, which gives it a little bit of gravitas there. Holding that an Illinois eavesdropping statute did not protect the police from a civilian openly recording them with a cell phone. So that's helpful case law from the Seventh Circuit. Here you have Fifth Circuit, Turner versus Lieutenant Driver from 2017. The First Amendment protects the act of making film, as there is no fixed First Amendment line between the act of creating speech and the speech itself. So when the cops try to claim, as the lawyers will do, they'll claim anything, that, well, yeah, the video footage itself, that could be speech, but you trying to record the video footage and pissing off the cops or getting in their way, allegedly, that's not protected because that's not the video footage itself, which is, I mean, it's a nonsense argument, but it's been made many times, but it's easily shot down, and the Turner case is a good source for that. Here's another one, Watersheds Project case, 10th Circuit, 2017. Now, that basically is laying all the case law out there, but there you have Third Circuit, 7th Circuit, 5th Circuit, 10th Circuit, So you have sources for this right to record in all these different circuits. And then here's the big one. This was the first one, the Glick case. Glick versus Knief, First Circuit back in 2011. And that was really the first federal circuit that found that there was this constitutional right to record police officers in public. And again, that was the Glick case, G-L-I-K. First Circuit, and Glick himself, I've gone over this before, Glick was a lawyer and somewhat of an activist. So here are the circuits again. So First Circuit, this is up here. That's up there in New England. Third Circuit, that's basically Pennsylvania, New Jersey, Maryland, or New Jersey, that area. Maryland's actually Fourth Circuit with us. Then you have the Sixth Circuit. So there's a 10th Circuit case. That's the 10th Circuit. There was a 7th Circuit case from Illinois. There was a 5th Circuit case down Texas, LA, Louisiana, and Mississippi. So we're waiting for a few more circuits to actually have cases on those. But those are pretty much the cases right now. And there was a 9th Circuit case. But that wasn't the same, though. But 9th Circuit was very early in recognizing the value of video footage of police officers. Obviously, that's where the Rodney King case and all that took place. Let's see. There was a Fourth Circuit case that I noted just briefly where they brought up this point that we live in an era where cell phones are increasingly used to capture much of what happens in life. And that was actually a West Virginia case against the state police from 2019. And a friend of mine litigated that case on one of the defense sides. So that is basically, I laid it all out there, went through all the immunity issues again. So that, we have Fourth Amendment, we have First Amendment. So now count 3, this is a Monel claim. So what is a Monel claim? Well, remember the Raleigh County Commission is in the case. That's how you sue the Raleigh County Sheriff's Office. The Sheriff's Office itself is not actually a political subdivision or something capable of being sued. It's a subcomponent, basically, of the county. And the counties in West Virginia technically are just the county commission. So that's how you sue Sheriff's Department itself as an agency in West Virginia, is you just say the Raleigh County Commission or the Mercer County Commission or whatever. And so this is basically a policy, custom, and practice case. So it's a pattern of practice type case. And this is the only way that you can sue these agencies directly. And you can't sue the state agencies. So you can't sue the West Virginia State Police, for instance, as an agency in federal court because it violates the 11th Amendment. But you can sue counties, you can sue cities, but this is how you have to do it. It's called a Monel claim. And Monel is the case that establishes this. And it's confusing, but it's a pattern or practice allegation. So there's no respondat superior in civil rights cases like you have in car wreck cases. So if an employee is driving a tractor trailer owned by his employer trucking company, the trucking company no doubt is going to be responsible for anybody injured or killed by that driver's negligence. That's basic law of private tort actions in most states in the country. It's not that way with civil rights cases. Just because a deputy is employed and acting in that capacity at the time that the victim was injured, whether it's a police beating or wrongful arrest or whatever, or illegal search, there's no liability automatically just for their actions. The only way to sue the employer directly is through what these are called Monel claims. And you have to show that there's an official policy or pattern or practice of civil rights violations happening. It's very difficult to prove. And I've only had one that I've actually had enough evidence to actually prove it, where a mayor had called a meeting and said, all right, all of my police officers that work for me, I want you to start just beating people up. And there was a whistleblower, and that was great. That was a great Monel claim. But otherwise, without something like that, it's hard to have a Monel claim. But here, I think there is one. Because for 20 years, admittedly, according to the judge, she had been doing this. She had been, as a judge, searching the homes of litigants appearing before her in family court. And every one of those had been a bailiff with her. possibly other deputies like we had here, but at least one employee. So you have the sheriff's department, a guy with a badge and a gun and arrest powers going with the judge to do this. And that is, that's part of why homes may get searched, or even people may give consent, because you have the threat of this is the government doing that. There's a guy with a gun and a badge. So the sheriff's department was involved in this. And this had been going on for 20 years and happened at least 12 times, probably many more. So whether or not there was a written policy, maybe there was, maybe there wasn't, it certainly was done as a practice and as a policy. So we alleged it. We'll see where it ends up. But as I understand it, after this hit YouTube, there was an express policy that came out that said, no more. You're not to go with any judge into any house. It's not to happen anymore. So I've heard. And that helps, I think, make a case for this Monel claim. So lastly, really, we have the 14th Amendment. Well, not lastly, but as far as the constitutional issues here. So 14th Amendment, what is that? Basically, that's your life, liberty, and property. Life, liberty, and property. So what does that mean? So your life, liberty, and property, the government can take it. They can take your life. They can execute you in certain states and under certain circumstances. They can certainly take your property and your liberty, as they've spent much of 2020 doing. But they're supposed to give you, according to our Constitution, due process of law. So the big 14th Amendment claim that is always coming up is due process. Now, that's confusing because there's different kinds of due process. There's procedural due process and there's substantive due process. Now, procedural due process is what we're dealing with here, and that's basically a notice in a hearing and things like that. So you can do stuff, but you have to follow the procedure. Then substantive due process, which we're not talking about here, that's like abortion. So abortion isn't written anywhere into the Constitution. You won't see anything about abortion in there. This prior Supreme Court judges for years and years and years, ever since Roe versus Wade, have implied that there's a right to an abortion, and they found it within the text of the 14th Amendment. So any new rights that are discovered by the Supreme Court, they pull out of the 14th Amendment, and that's referred to as substantive due process. Really, whatever the hell that means, I don't know. But that's what it's called. It is confusing. There is also a due process clause in our West Virginia Constitution as well, which it doesn't really matter in this case because we're talking about federal rights. But there is authority for under state law that you have due process of law, supposedly. But how do you explain everything that's happened in 2020? I don't know. So basically, what we have here are violations of the rules of the rights that litigants should have, even in family court. So you can be entitled to due process. I mean, you could be talking about DMV actions with suspension of your license. You could be talking about criminal cases and jury trials, or you could be talking about family court. Yeah, there are due process concerns in family court. Everybody's entitled to notice in a hearing before their kids are taken away and given to the spouse, or before their money's taken away and given to the spouse or ex-spouse, or even before they're held in contempt and thrown in jail by a family court judge. I mean, they can do these things if they follow the rules and they give people the notice and the hearing and all that. And the whole point here is where we get into the actions of the Judicial Investigation Commission, which is really good. So they ended up filing a 50 or 60 page brief in response to the Judicial Hearing Board, wanting to know whether or not there was authority to search a house. And so they briefed all these issues, and they went a lot into the 14th Amendment, how really this whole thing was set up so as to favor certain parties in family court and to make it unfair for others. And what is that? That is violation of due process and also violation of equal protection. So there were a lot of things that, because my client was representing himself, that he didn't get that other lawyers would have gotten, that led to all this stuff. So according to the Judicial Investigation Commission, the judge, and that's when they say respondent, that's the judge. The respondent failed to hear all of the wife's evidence. She heard none of Mr. Gibson's evidence. So how important is that? She didn't even have to hear all of the wife's ex-wife's complaints about I didn't get my stuff. Basically just stopped it and went to my client's house before hearing any of my client's side. Didn't hear any of my client's evidence. That is a lack of due process. The judge made no findings or conclusions. Didn't follow a process where it's given to you in writing what the judge found as far as the facts and the law are concerned, so you can appeal it to a higher court. Wasn't provided with any of that. Never gave my client opportunity to purge himself of the contempt. Now, what does that mean? The rules of contempt, and that's where a judge can hold you in contempt for not following their order. There are rules that have to be followed. They can't just say, all right, that's it, damn it. I'm, like you see in the movies, like bailiff, take him into custody. No, in real life, there are rules. So there's law that says that you have to be given an opportunity to fix the problem before you get held in contempt. So if you owe $100, you have to be given the opportunity to pay $100 before you're held in contempt. So that's what it means by purging yourself. So the judge never gave my client the opportunity to purge himself of the contempt, the alleged contempt. Okay, he was never found in contempt. The judge also never entered an order granting or denying the ex-wife's contempt petition. So a court, as they noted, speaks only through its orders. There was no order here. Now, was that just sloppy or was it purposeful? I don't know, but it certainly wasn't due process, was it? And this is the JIC speaking here. The judge inappropriately went into my client's home, searched his house, and seized his property. In doing so, the judge failed to apply an appropriate statutory remedy, which would be the actual contempt procedures, and violated the Code of Judicial Conduct by engaging in an improper search and seizure. So, had she applied the contempt statutes as written, the respondent would have avoided judicial discipline. So there it is, right from the folks that's all they do is investigate complaints about judges. So she engaged in non-judicial actions, acted outside of a judicial capacity, did things that judges generally aren't supposed to do. And these are all alleged in here. And that's going to be important to getting around the judicial immunity. So in each of these areas, this is why it took so long, really. I mean, you got to make your allegations in such a way as to survive a motion to dismiss, and then hopefully beyond that. So that's due process. Also under the 14th Amendment, there's a clause in there about equal protection. So that is what protects us from the government denying to any person the equal protection of the law. So that's discriminating against people, basically. There's different types of groups of people. Some that are you can discriminate more than others, believe it or not. But what we have here is my client being treated unequally and unfairly, discriminated against because he was a pro se litigant. In other words, he was representing himself in court, which is common in family court. And lawyers, particularly this lawyer, is getting favorable treatment, getting unfair advantage. And that's always going to be arbitrary and irrational under the law. So that would violate equal protection, and that's also a 14th Amendment claim. And I explained exactly out from the horse's mouth why that is, because here is an excerpt, which we're lucky to have, of the interrogation of the judge by the disciplinary folks. So here is the investigator, I believe, asking questions of the judge. This is after the YouTube video came out and after the public knows about it, and the complaints begin and the investigation begins. So the investigator's asking the judge, why you do these things. So she says, the lawyers love that I do this because it enables them to say, be truthful in your disclosure. And this means talking to the poor sap on the other side of the case, like my client. You better be truthful, because if you try to hide something, she, meaning the judge, might go out and look for it. Again, this is the judge explaining that. And the investigator asked, well, doesn't that put the parties who are represented by lawyers, at an unfair advantage because they're aware of this while the pro se litigants are not? Well, possibly. But again, that's only happened twice that the pro ses have been involved. And so how do you decide when it's appropriate to do this? Well, generally, it's the attorney who asks me to do it. And there appears to me, and it's generally agreed, that if I don't do it, the party without the asset they are awarded is not going to get it any other way. It's sort of confusing, but you can see that the investigators just sort of beside themselves here. So just by what I'm hearing you say, it does put individuals with lawyers at an advantage because they know to ask for this treatment, while pro se litigants, such as my client, do not know to ask for this. They don't know that you go and will search somebody's house. And do you agree with that? Yeah. Yes, except I'll make this caveat. The two pro se cases where she admits to doing this, both had a lawyer at one time. Well, what the hell difference does that make? So that's pretty much it. The benchmark is if the lawyers agree to go, that she should go. But that still doesn't explain why in this case, there was no lawyer representing my client to agree to it. My client didn't agree to it, wasn't even given the opportunity to object to it. And then once he got there, expressly did object and was threatened with arrest, and she still did it. So favorable treatment for one group of people. And this is a common theme for family court, is that people think that if you try to represent yourself, you're going to get unfavorable treatment. And this really is evidence that exists, and it's provable evidence. It's an admission. Lastly, I think this is lastly. All right, this is the last claim from this case: conspiracy with a state official. Now, this is how the ex-wife's lawyer is a defendant in this case. So where there is this long time practice, agreement, relationship, or understanding, where the lawyer has this ability, as she said, to ask the judge to go search somebody's house, or the perceived ability to request that she search somebody's house, you had a conspiracy with a state official. The judge is a state official. This particular lawyer, as we allege, would threaten to invoke this ability, as he did to my client, during settlement negotiations with other attorneys and pro se litigants in order to gain an advantage. So this was an ongoing relationship, understanding, and agreement that actually occurred on March 4th, 2020, when he indeed got the judge to go to my client's house. And even the night before, he called my client and said, if you pay $5,000, we won't do this. Otherwise, we're going to do it, or I'll see you in court. So my client didn't pay $5,000, and look what happened. He got the judge really without even asking, hardly. And we believe that that's because the deal was made ahead of time, but got the judge to go to my client's house. So that demonstrated this sort of quid pro quo was going on. And also that there were these meetings going on, these ex parte communications, which just means one party's not present. And that was demonstrated by the voicemail from the night before, where he said, the judge wanted me to call you and relay this settlement offer. So you're not supposed to be talking to the judge without me present. That is an inappropriate and unethical ex parte conversation. But that is what's being demonstrated here. So you have this conspiracy, this relationship that's going on. Well, the judge was there for 26 years. The searches have been going on for 20 years, and this lawyer had been there for a long time. He's not a state official, but he's been acting in this relationship with this judge who is a state official, and going and doing things, or at least in this case, that were violative of the federal constitutional rights of my client. So where you can prove that, then you can bring in a private party in a Section 1983 case for civil rights violation, which you can't generally do otherwise. And what else do you need with a conspiracy? Well, you need a common goal. They had a common goal here of utilizing the power or perceived power and discretion of a family court judge to assist one party in particular. And that happened in this case, against pro se parties. What else do you need in a conspiracy? Well, you have an act in furtherance of the conspiracy. That's what you always need, is an act in furtherance. You can't just have the deal and nobody takes an act, a step towards committing the conspiracy or achieving it. And so why would any judge do this? Well, family court judges have a high turnover, in my experience, compared to other judges that seem to stay in their position for their entire careers. They have high turnover. And this particular judge was able to stay there for a period of over 26 years. And we believe that there was sort of a quid pro quo here, that there was, we know of at least one big maximum campaign donation, at least in the last campaign election, and general political and social support that would at least partially assist an elected official or a family court judge to stay in that seat, which might be difficult to keep when you're upsetting 50% of the people at every hearing. So you had, that sort of answers the question of motive. Well, why would a judge want to do something that there's no right to do, to make the lawyers happy, who in exchange make them happy? I mean, I don't know. It's a twisted sort of deal, and maybe it doesn't make sense to most people, but I guess if you've been in family court, it probably does. So that's basically the allegations. We didn't get through the factual allegations, but they're all laid out there. So it was filed today. And so that is going to be proceeding in the Beckley division of the federal court system. And it's, I'm tired of just watching along with the disciplinary process. And now it's our turn to proceed. So that's pretty much it. And I'll put the complaint up, and I was waiting for the stamped version with the case number on it before I posted it up, but it will be up there. As I assume that you'll see some media reports of it here soon, but the next step is that the defendants will be served, and then we'll really immediately, pretty quickly, head into the disclosure phase where the parties share information, and hopefully we'll get into the discovery phase where we get to take depositions and issue subpoenas and things of that nature. And that's basically it on this, whether or not there's any questions. What resolutions are you asking for? Well, that's a good question. If you're talking to me, the only resolution we can get in a Section 1983 civil rights lawsuit is money damages. So that's what we're asking for is money damages. If not, and also, of course, court orders in the process declaring that certain things are civil rights violations, and that supports the money damages. But the ultimate relief available is just money damages. Brian, did the judge get disciplined by the Supreme Court? It hasn't been heard by the Supreme Court yet. I suspect there will be discipline. The problem is that the discipline, it was reduced from the agreed discipline, which the judge with her lawyer agreed to. It was reduced to something less. So the question is the Supreme Court going to keep it at something less, or are they going to pump it back up to what it should have been? I wonder if this judge ever searched the female's house, or was it always the male's house? That is a common complaint about family court, is that one sex is favored over another. And that is true to a certain extent. But here, to answer your question, if you look at the complaint or rewind the video, I actually talked about a female victim of this thing, that it was threatened that her who she alleged was her abusive ex-husband, was going to get brought in her private residence by the judge at the request of a lawyer. And that was leveraged over her to get her to actually cut a check to the ex-husband while they were in court. So yeah, that's a female victim of this that was actually very traumatized by it, that I spoke to personally, that didn't want to be actually named. But yeah, so that was a female's house that was searched. So I don't have any indication that this was something that it was just about, sticking it to men. It was, I think it had more to do with who the lawyer was on the other side, and whether they were part of the inner circle and entitled to this treatment, or at least had knowledge of the ability to do this. But that's just my guess. Hot mess. Are you looking for additional litigants for a class action? No, I don't think this is a class action sort of deal, because the judge only admitted to doing this, 11 or 12 times over the course of 20 years. So I think there would be additional actions potentially for the people who were actually had their houses searched, or maybe even were threatened with it, but certainly who had their house searched. But the problem is also going to be a lot of those other people, according to the judge, had lawyers that allowed their client's home to be searched and didn't object to it. And if that's the case, then the question arises, well, can they sue over it? Because they were represented by a lawyer, and so their lawyer consented, and therefore they consented. But it certainly will be an interesting question, because at the same time, then the lawyer might say, well, we knew that there was no way to stop her from doing this. So, but if that's the case, then why didn't at least somebody appeal it to the Supreme Court and make a record of it? Bubba, John, do you really think a group of judges are going to rule against a judge and make case law? I mean, I hope so. I hope so. I really don't know. I mean, there are lots of cases against judges out there, just not for this particular thing. I think it really would be a shame if they get what they're asking for now, and some sort of West Virginia Supreme Court decision finding that there's some sort of a gray area or possible right for a family court judge to enter a litigant's home. I mean, I don't see that happening, and that would be outrageous. But that would be sort of worst case scenario. All right, just trying to sort through the comments with actual questions which might be on point. Alpha may try to make it down to Flatwoods. Jenna is a national treasure. Talking about Jenna Ellis, who will be on the panel with me as one of the speakers at the Independent Party, or they call it convention in Flatwoods, West Virginia, April 10th. So I'm looking forward to that as well. I've never met her before. Hey, Keisha, I appreciate that. Joe Connors, that's all we can do. That's all we can do. Now, generally in these types of cases, the state's insurance company is defending and paying out these cases. So generally there's very little actual financial accountability in these types of cases, but this case is unusual. So who knows? Save the Humans. Do you see this going to the Fourth Circuit to be reaffirmed that videoing of public employees is a right? Well, I was talking about that earlier. I don't know. I can't believe it hasn't really been just directly on point at the Fourth Circuit before. The Fourth Circuit had this really terrible unpublished per curiam case. I think it was called like Seismecki or something like that. And it wasn't binding legal precedent, but it said that there was no clearly established right to video record police at the time that the conduct in that case occurred. And it's been brought up in several cases and in other circuits since then, as it's been explained why it's not really applicable. But I don't know. I hope maybe they picked this case to do it. I mean, it's got to be a right in the Fourth Circuit. So since this is a civil rights lawsuit and not a criminal case, maybe they'll take the way out of going with qualified immunity. I don't know. But then again, this is on private property. So it's not a great one for them to even get qualified immunity. Daniel, good question. Could the judge have signed her own warrant? No, she couldn't have, because she's a family court judge and they're not allowed to issue warrants anyways. And you'll see, as I explained, if you read through the lawsuit, family courts in West Virginia, and I guess other states as well, they're creatures of their legislatures. They're not in the Constitution or anything like that. The legislators created them and gave them certain limited inferior powers. So they're literally inferior courts to other courts. So they only have these limited powers, and none of which are to issue search warrants. Now, what could a family court judge do? And I've seen family court judges do this. And in fact, this is how it's done. It's not the first time that it's come up that one party won't give, or allegedly won't give, private property, personal property to the other ex-spouse. This comes up all the time. So what are you supposed to do about it? Well, you can actually hold them in contempt. If you follow the rules, you can put them in jail. You can fine them. You can even issue an order that something be seized. For instance, if and I've seen this before, if one of the spouses or ex-spouses has a bulldozer that's worth $10,000, and there's a debt owed, there could be an award of the bulldozer to the other spouse or to the other ex-spouse, or to satisfy something that's owed. And basically it's a court order directing that bulldozer be seized and given to this party, or sold, and the funds distributed via X, Y, and Z. So how does that work? You have a court order providing for the seizure, and then who does the seizing? It's not the judge. The judge doesn't sign the order, then go out there and seize the bulldozer. Of course, it goes to law enforcement. It goes to the sheriff's department, and they follow they follow the rules. And the sheriff's department, law enforcement, then is going to execute the order to go pick up the bulldozer from wherever it is. That's how it works. It's not judges or the judiciary that actually seizes anything or searches and seizes anything. It's the executive branch. It's law enforcement. It's the sheriff's department. And that's why you don't see other cases like this. So that's the proper way of doing it. There could have been a finding of contempt. There wasn't. And there could have been an award of money, or there could have been a court order that says you get item X, Y, and Z. But they can't just go in your house and look for it. It would have to be something that was executed according to the rules by law enforcement. But it's irrelevant to this situation, because that's not what happened. Certainly, it did probably make it easier for some of the lawyers to avoid following those rules. And because you can just get the judge to go right there. And if the chainsaw is in the guest bedroom and it's in there, then we're going to go find it. So, but efficiency is not the goal in a democratic republic or in a fair legal system. It doesn't matter. We're really looking for inefficiency. Inferior powers seem pretty powerful to me. Yeah, they don't exist, but they've been wielded. But then again, there was no power for our governor to make us all wear, a diaper on our face, and yet he did it. The powers don't exist, yet he did it. Only special judges sign warrants. No, in West Virginia, and this is all going to be state law, but in West Virginia, it can be the magistrate judges, which generally handle the misdemeanor crimes. and they probably do the bulk of search warrants. And that can be a problem because they don't even have to be lawyers. They just have to get elected. But that's another video. Or it can be the circuit court judges, really the judges that hear the jury trials, the felony crimes, and they can issue search warrants. And one interesting tidbit I learned was that whenever the FBI or the ATF, or these federal agencies, when they get a search warrant to come in and raid your house or business, they specifically require a search warrant from a circuit court judge in West Virginia, and they don't allow, so I'm told, warrants just as their internal policy. They would be legal under West Virginia law. They require circuit judge warrants and not magistrate court warrants. But yeah, I mean, those are just the judges that preside over criminal cases. And they're the ones who are supposed to be the neutral and detached, unbiased judge who looks at the allegations of the police officer that are given under oath and determines whether or not that's enough to be probable cause, which is the standard to perform a search. I think I saw Ray's trying to pay attention to the comments here at the same time. I just live the churches where the churches are closed, when churches and well, not quite following your the way you wrote your sentence there, but I understand what you're saying. Yeah, the COVID fascism, the closure of churches, supposed to be a separation between church and state. Jason Sherman, unfortunately, there's nobody to hold prosecutors responsible. You know, prosecutors are very similar to the immunity that judges have. And it's the same sort of deal, a similar sort of deal. If you can show that I have sued prosecutor or prosecutors before, if they step out of their job as a prosecutor and into their job as a different job as like a police officer or an investigator, they actually will lose absolute immunity in theory and then only get qualified immunity. So it can happen. But on another note, you may have seen in the news, I think it was today, that in New York, there was an assistant prosecutor who got busted working as a DoorDash driver because he was supposed to be working remotely from home. And instead of working at his house, he's out delivering meals via DoorDash. I think he got fired. I'm not sure. Keith Gregory, by the time the government screwed around collecting a bulldozer, there would be no money left to be allocated. Well, I mean, is that an argument to allow family court judges to search houses? That is actually the argument they're making. Because look, if we don't do this, the ex-wife she's going to lose out on that property that's supposed to be hers. And that can't be an argument that we go with, because even assuming that's true, and judges shouldn't be assuming, but even assuming that's true, I mean, that's a slippery slope. I mean, if we allow family court judges to just go in somebody's house and look for things, you know, especially even without a finding of probable cause or a warrant or anything, just look for things just because it was alleged by one party. Well, look at how much just harm could be done within the family court system right there if we allow that. But what other harm can be done? Because we're really setting aside Fourth Amendment rights. If you let the government have an inch, they're going to take a mile. If you let a family court judge come search your house, well, then you're going to let the health inspector come search your house. You're going to let the COVID czar come search your house. You're going to let, I mean, we could have an endless list of all the different government employees that would get to come in your house. And that it's irrelevant because it would violate the Fourth Amendment. I mean, the Fourth Amendment does not just apply to criminal cases. It applies to administrative. It applies to any time the government officials are coming into your house. It just does whether or not you agree with it. Which Keith, I'm not sure that was your point. Your point may have been, and I would agree with this, that even crime wouldn't pay if the government ran it, because the government is incompetent. And it's full of people who either couldn't or didn't have the courage to try making it in the private sector, where you have to actually perform or provide a product or a service that is good enough or efficient enough or clever enough that somebody will part with their hard-earned money to pay for it or hire them. Government doesn't have to deal with that stuff. They hire people based on someone was available, or I mean, whatever. I mean, who cares? And I've worked for the government before. And to give prosecutors credit, and having worked as a prosecutor myself at one time, as in the criminal world, you do have to try cases, so you do have to perform. And prosecuting is a piece of cake. So if you're a prosecutor and you're losing cases, they probably won't keep you around because you're expected to win. You should win. Drink water. Thank you. I used to have that problem when I would go in front of this particular female federal judge. Scared the hell out of me. Some other lawyers who were with me, they were kind of laughing after the hearing, or this happened a couple times, but I'd get up there back before this stuff was remote, and you had to walk up, and this, like, all the federal courtrooms are super, fancy, intimidating. And you walk up there, and then she would just grill you. But Mr. Bryan, and she was sharp, and she was intense. And so I'm just sitting there, and I didn't have a water or anything. And my mouth is just getting dry, and I'm dying because she's just hammering me, put me on the spot. So I learned to always bring my own water in case I don't have any water sitting there, to avoid that. But anyways, drink whiskey. Well, I happen to have that as well. So proper number 12. But that doesn't necessarily fix that same problem. I have to have both. Thoth. I think everyone in America has the IQ of an eggplant. I think that's absolutely, well, not absolutely right, but I think that's a good point. For the most part, we are functioning at a very low IQ, low information level. And somebody just given me this example the other day, that they were at this lady was at a grocery store, and it was a racial thing. So there was a woman who was a minority, who saw a white lady in front of her in line at the grocery store, and the white lady had given the card to the cashier and paid for her food. Pretty simple stuff. Then it came to the minority lady who, sort of had a chip on her shoulder and had an EBT card, and it didn't, I think this was a true story, didn't have enough money on it to cover all the stuff that she was wanting to buy. And so she pitched a fit about, well, it's not fair that, because of skin color, that the white lady who was in front of her didn't get the same treatment, that she was able to buy all that food that she wanted, and yet she must be discriminated against because she wasn't able to get all the food that she wanted to get. And to make a long story short, the lady in front of her had used a credit card that had credit on her account that she was paying for, and the other lady didn't understand that wasn't an EBT card, that it was a credit card, and she was paying for it. It wasn't just that the government feeds you, that the government is giving you food based on your skin color or whether or not it likes you. I mean, there are people that believe that because they've been subjected to all this propaganda and all this race baiting. That is the sad reality, is that there are people out there, large numbers of people, who think that way, or think that cell phones come from Obama phone. And it happens here in West Virginia. I mean, you have the example that I've used before, and they don't like when I use this example, but you have a county in West Virginia where this is a good example of, you can't just assume that people are understanding what's going on. You have a county in West Virginia, this is Mcdowell County, West Virginia, that has like the worst economy of any county in the entire country. And how did it get this way? It was once a thriving area I think it had like over 100,000 people in it once, because coal was thriving. And you had a lot of construction, people moving in, you had lots of jobs. And then it dried up like right around the late 50s, I think, early 60s. And that was right around JFK was here. He was campaigning in West Virginia. He was a newly elected president. And so they started in Mcdowell County, West Virginia, where all these coal jobs were disappearing, but you had all these people there. That's where they started the whole food stamp program, where they really, for the first time in world history, it goes from just letting the human population do its thing, where if the jobs dry up, they have no choice but to move somewhere else where there are jobs and try to survive. We go from letting nature take its course, basically, or even letting capitalism take its course, to, all right, well, here's what we're going to do. Government is going to come to the rescue. We're going to feed you. We're going to come up with this food stamp program, so you don't have to move and go get a job or chase opportunity or try to thrive in your life or follow the American dream. Even you just stay right where you are, and we're going to feed you, literally. And fast forward 60, 70 years later, and you have what you have now in McDowell County, West Virginia, where you have like 10,000 structures that have to be torn down. You have this blight everywhere. You have the worst economy. It's so bad, even Walmart went out of business. I mean, look it up. The Walmart, McDowell County, West Virginia, looks like a ghost town. Empty parking lot. It's out of business. They call it a food desert down there because I don't know. So many people are living on food stamps. The private businesses aren't wanting to go down there to try to earn a profit. So they call it a food desert. So you have people living off the government. And what does it lead to in the end? You have all this blight, this physical blight that you can see of just buildings and structures falling down everywhere you look. But then you have the health toll, which is tragic. And I don't recall exactly what the number was, but you had like the lowest life expectancy in that county out of any county in the entire country. So it took a health toll on them. So men they only had a life expectancy of like low 60s. I mean, that's it. And that was a county in West Virginia. And you can track it. It's a great example because you can trace it exactly to the cause. And that is government stepping in and literally feeding people instead of letting a private free country take its course, where if jobs dry up, people will go and find better jobs somewhere else rather than just staying in the same spot. Yeah, food programs are a big problem. And is that what we want? Is if people, they can get a cell phone and a big screen TV and food to live off of, and they're happy, and that's just it, and that's the goal of life, and that's what the next generation learns. And then what do you really have? And I've experienced this down there. Is you have now the grandparents raising kids, because then you have drugs, and I think that county. What came next? You had the drug problem, the opiate. You had one of the worst OD rates anywhere was in this particular county. And that's what's going to happen anywhere where you let the government just take care of people instead of the people following the American dream and trying to take care of themselves and better themselves. But yeah, how do we even get on this topic? But it's scary. You can't assume that people even understand or want to understand. In fact, that's probably a good explanation for why so many people are just okay walking around, or not just walking around with a mask on their face by themselves down the sidewalk outside. But I saw this family just last weekend in Ohio. They had this little tiny kid. I was surprised could even walk. A baby, but a toddler, I guess. Had this huge, just designed with a cloth mask design on it. the cloth mask is not going to work anyways. But just, it was huge, covering this baby's face. I mean, she could barely see out. And they were in the restaurant, but then they get out of the restaurant, and all the parents take their masks off, and they're talking, walking down the sidewalk, and no one takes the baby's masks off. This baby's like about to wander into traffic, can't see where the hell she's going. And I just felt so bad for this kid. But what are we doing to our kids? You can't fix stupid. That's true. It was a huge problem before the opiates came around. That's a good point, is when people get everything from the government and they see government as their source of income, or maybe their God even. I mean, everything comes from the government. They're going to look at everything that the government says as, the Bible, basically. Jim, it is a prime example of going away from the free market. It just absolutely is. And it's a shame, because there's really, really great people down there, and I've represented some of them, and in a beautiful country. And it would be beautiful without all the blight that's around. And it is not just that county. There are other areas, but anywhere you see those problems, in my opinion, you can trace it back to the government coming in to fix the problem. And that's what we're going to see now. I mean, how many people, I've heard that restaurants a lot of times now can't even find people to work in them, waiters or waitresses, because who wants to work? I mean, hell, they're getting free money from the government right now. Statism is religion. Well, the mask, yeah, I never would have even foreseen this, but all the COVID fascism, it's even worse than a religion. It's like a cult. It's like idolatry. And I think Daniel Horowitz had a piece on this where he called it the cult of mask idolatry. And that's really what it is. I mean, they don't even care if the mask works. In fact, they say they don't care if the mask works. It's all about, you just better do it, or else you don't care about them. You don't care about anyone else. You're not a member of this religion. It's really bizarre. Daniel, Van Halen or Van Hagar? Definitely Van Halen. Wearing 6 masks will cure racism. Fascism is where the government runs your family. I was attacked in Circle K by a mask-shaming woman. I was attacked in a coffee shop. Really, the only time that's happened to me. Save the Humans. Do you see the world becoming the movie Idiocracy? I actually haven't seen that. So many people have told me to see it. I guess I need to go watch it. But just based on the name of it, I do see that. And Biden says to wear 2 masks. And isn't that funny? Because Biden has been vaccinated. Yet he says to wear 2 masks. Really, is that any different than, do you remember when Al Gore went through, or former candidate Al Gore, who's former vice president, he's got Secret Service with him, right? So Al Gore's got Secret Service with him. He's going on an airline flight after they opened the airlines back after 9/11. This is my recollection. Maybe I'm off a little bit, but he's going through TSA. And so TSA is doing the big search. Remember, they were doing random searches where they're feeling you up. I mean, they're doing this super search. And since they don't want to be racist, they don't want to do it to somebody that looks like they're from the Middle East. They want to show that they're not racist and all that. So they're doing it just complete randomly. So random, in fact, that they picked the actual former vice president of the United States with his Secret Service agents in tow, who obviously they got guns. And yet they're searching Al Gore. And so they ask Al Gore about it. They're like, well, what do you think about that? He's like, oh, well, I love it. I think it's a great thing. Well, really? Why? Why is it a great thing for TSA to search you, the former vice president who has who has Secret Service with you. So that means they're not searching somebody else who could actually be, one of these terrorists. I mean, why? You know that you're not a terrorist. You know that you don't have, well, you do have a gun with your Secret Service agent. So it's just theater. And you think it's good because it's just theater. Because you're all about manipulating the American people and say, look, see, I'm wearing a mask too, or I'm being searched too. It's all political theater. It's all propaganda. And it's really, I guess they've been doing it for a long time. Daniel, I'll check out that podcast. Borderline. Appreciate it. And let's see, that's pretty much all I wanted to go over. Don't usually go over 2 hours here. The only other things I guess I'll point out is, we talked about the mask tyranny. I guess lastly, look at the gas prices. You have the economy with the jobs. Big shock, right? The jobs are moving to Mexico. Gas prices are going up, and like some of these idiot union members are like they're outraged now, or the union leaders. They endorsed Joe Biden, and yet they're in the energy sector, and they're shocked now, or even in the car production sector, and they're shocked now that jobs are being lost or moved to Mexico or just signed away with an executive order. Who was shocked at that? Who would be shocked that gas prices are, $3 a gallon right now? You could find probably millions of people predicting that and warning against that. And yet, we have such a low information exchange of ideas that people are shocked about that. And I think it's also purposeful that, these environmental extremists, these leftists, they want gas prices to be at $5, $6, $7 a gallon. They want it to be unaffordable, just like they wanted to make coal mining unprofitable, so that they reach their policy objective of getting rid of coal mining. They want to reach their policy objective of getting rid of trucks, and they don't like that the American people can buy trucks and drive wherever they want to drive when they want. They want them riding on trains. They want them going where the government takes you when the government says they want to take you. So they want to make gas, just unobtainium. So, I can't imagine why anyone's shocked at that. All right. Yeah, I appreciate. I agree with all the stuff that you guys are saying, and really, it's not. There's really nothing even interesting about it. We all knew it was going to happen. It's happening now, but all we can do is fight fights that can be fought. Individual fights, and that's why we're taking on this case and the family court judge search case, because that's just another example of government officials doing what they want to do when they want to do, and they have to be challenged on it. And the funny thing is, like, looking like this guy, Nick. All right, Nick. I'm an intelligent idiot. Let me guess why. Because you don't like anything that I say that gets into politics. Why? Because you're a good Democrat or leftist, and you just don't understand the irony. So you think you support liberty, yet you voted for Joe Biden, who is wearing 2 masks, not because he wants to wear 2 masks, but just to keep the charade up, to try to manipulate you and your family. And he wants to make your kids wear a mask on your face, or not even go to school, just to help, his union base with teachers. That is not liberty. And yeah, Kamala Harris is a cop. Exactly. Kamala Harris was a prosecutor and the Attorney General of California who put more people in prison than probably anybody else in the country. What does that have to do with freedom or liberty or liberalism? Is that liberal? Is that liberalism? Is that progressive? No, it's really actually far right fascism or far left fascism. So while you disagree with me based on what you think you know about politics, I hope you take a second look at the people that you voted for, and instead of getting upset at me, hold them accountable. What's wrong with more freedom? I don't support a party. I don't support the Republican Party. And I sure as hell don't support the Democrat Party. All I want, and if you disagree with this, fine. If you want to unsubscribe, fine. What do I want? What do I believe in? Less government, less taxes, more freedom. Stay the hell out of my life, the hell out of my business, the hell out of my social activities. Stay the hell out away from me. Let me be. Less government, less laws, less taxes. I mean, who can disagree with that? I know who can disagree with that. But if you are really a liberal or a progressive that you think you are, okay, well, maybe you're not. I don't know what you are, Nick. I don't know what you are. But, I support freedom and less government. If you disagree with that, then that's fine. So if, a lot of times I completely disagree with what the Republicans are doing. So politics is a part of the liberty and the Constitution discussion. And, for the most part, it's been one side, and that's the left and the Democrats, that have been pushing this crap of turning our country in from a free country into one that everybody's, marching around with masks on their face that they don't want to wear. They just do it. And that is crazy. It really is crazy. Anyways, that's for a different video anyway. So it's about that time. And I thank you, for watching, and I'll sort of leave you with this. And join me again, by the way, Wednesday night, 6:30. Mondays and Wednesdays work 6:30. So I've already got something awesome I want to do 6:30 on Wednesday evening. So join me again if you can. And also something cool planned for after that this weekend, actually. But let me leave you with this. So one of my favorite things that Mark Twain said, and I think that applies to 2020 and 2021. And that is, in the beginning of a change, the patriot is a scarce man, and brave, and hated, and scorned. When his cause succeeds, the timid join him, for then it costs nothing to be a patriot. So thanks for watching. Remember that freedom is scary, and I'm doing my best to point that out to everyone who listen, and fighting the battles that come to me that I can help fight. So thanks for watching. You know how to get a hold of me, civilrightslawyer.com.